It's a great pleasure for us. It has been a pleasure to read all your works during the last years, and I'm gladly saying that antitrust has become a day-by-day subject in all in all meetings we have now, from the university classes and to weddings and parties, etc., due to the big tech discussion. So we are only talking about antitrust now.
All the time.
All the time. It's soccer, Supreme Court, and antitrust now.
Not in that order.
Not in that order, no, actually not. Actually, the Supreme Court is much more commented here. But thank you, Professor. Please, you can go ahead. Thank you, everybody. Thank you, everyone, for joining us in this course. Thank you.
No, thank you all. I'm so grateful to IBRAC. I'm so grateful to all the attendees for the opportunity to do this, to speak to a competition community and the system that is as important as any in the world today. Not only astonishing in its accomplishments in the Western Hemisphere, but globally now, setting the pace in so many respects with path-breaking cases, with extraordinary success over the past decades in building an effective system, so that what is taking place now is not simply important for Brazilians, but important for Latin Americans, important for all of us who live in this hemisphere from its top to its bottom, and to the global community that follows developments in the field of competition law. It is humbling and an honor to speak with a community that has done so much to make this such an important element of policymaking for the good. I'm going to bring up my slides here.
Yeah. Well, while you do that, Professor, just some initial comments here so everybody could be on the same page. Well, I think it's for some time now that we're trying to bring Professor Kovacic to do a course in Brazil for Brazilian lawyers and economists, and I think this was fortunately the case that we could organize that this year. So I thank Professor for that. I think Professor Kovacic dismissed introductions, but I just would like to remind everyone that he's currently a professor of George Mason University. He was a FTC General Counsel from 2001 to 2004, member of the Federal Trade Commission, and chaired the agency from 2008 to 2009. And since August 2013, Professor has served as a non-executive director for the United Kingdom Competition and Market Authority. This course is going to be of 3 days. Today, just this week is going to be Wednesday. The following 2 weeks, the course is going to be on Tuesday. Professor, for the sake of knowledge, we have here Brazilian lawyers, economists, several companies, friends from Argentina. We have a lot of people from CADE. We have some people from the oil and gas regulator, ANP, Central Bank, and Brazilian Congress. So it's a very diverse community watching your classes here. And I just would like to remind everyone to leave your cameras on so Professor could see our faces and interact with us during his presentation. We're going to mute the mics. If you have questions, we can raise those questions directly in the end of the presentation, or send them through the chat room, which we can organize this as well. So, Professor, thanks a lot. Again, it's an honor and a pleasure for us to have you on board for this course.
Bruno, thank you. The honor and pleasure is on my side, and I'm thrilled to have the opportunity to do this. As Bruno said, please do, as you have comments or questions, pass them along through the chat or to Bruno, and we'll make sure that we allow a generous amount of time to address this. Let me give you a bit of a roadmap through today's presentation, which focuses on agreement and single firm conduct issues. To situate this in what's taking place in the United States, and Lauro described a set of developments that I think is making competition law front page news in a variety of jurisdictions. And I want to give you a sense of how that's happening in the United States, how there is a fundamental debate taking place now about the aims, the substance, and the enforcement of competition law that has important implications for policymaking going ahead. And I will just highlight one effect of that. It means that the enforcement process is expanding, and it means that the possibility for a redesign of the competition laws by legislation has become greater. Not a certainty, but it's becoming greater. And I'll talk about what might happen to take that possibility and bring it into the real world. So I'll tell you a bit about the context, a bit about how it's focusing in particular on the discussion of what the goals of the system should be, changes in legal doctrine governing the filters that courts use to determine who can proceed with lawsuits and who cannot, the recent interesting cases involving agreements, and the most important formative case I'm going to talk about is the American Express Ohio case dealing with two-sided platforms. That's the case that's having the biggest impact on the development of policy, not just in agreement jurisprudence, but in other areas too. Single firm conduct, here I'm going to focus on the most important case running in the United States right now. That's the FTC's case against Qualcomm. But as I'll mention, by the end of this week and at the latest next week, our Department of Justice is likely to file a major abuse of dominance case against Google. And it will be joined by a number of our member states who may also decide separately to bring a broader case than the DOJ does. In going through these topics, I'm giving you my views only, not those of the Competition and Markets Authority, but my experience there, including attending this morning's board meeting, does influence my thinking about how trends outside the United States are affecting the development of policy inside the United States as well. There's a big debate going on now. It's a debate that is capturing attention in academia, among practitioners, and certainly among legislators. And it's a debate that involves four groups. One group, which might be called very traditional in its orientation, says, leave the system alone. It says the basic framework of doctrine and policy is in the right place. So don't try to touch up the smile of the Mona Lisa when you go to the Louvre in Paris. The Mona Lisa's smile is just right. Don't tamper with it. And if you want to do something at most, you make very minor adjustments. Maybe you want to adjust the frame in which the Mona Lisa portrait sits, but don't touch Mona Lisa. She is a masterpiece. The second group says, do much more with what you have. This is a direction to the competition agencies to use their existing powers more aggressively, more creatively, and with more courage. To stop worrying about losing cases and start thinking about the benefits that could come from bringing more cases, including cases that have large economic consequences. The third group accepts everything the do much more group says, but says we want more. We need new regulatory tools to oversee the behavior of large platforms. And this is part of a global trend. Now, notice in how many countries now the policy solution for big platform firm behavior is moving away from traditional antitrust. It's moving in the direction of regulatory policymaking with rulemaking authority, ex ante controls and conduct prescriptions that involve a mix of consumer protection, data protection, the enforcement of contractual provisions that bar the unfair exploitation of a dominant bargaining position or a bargaining asymmetry, traditional public utility techniques for regulatory oversight, such as line of business restrictions. So the third group here says, give antitrust a bigger test, but let's create other regulatory tools that may be better suited to deal with the wide variety of problems that platforms pose today, certainly those operated by dominant enterprises. And the fourth, and I use a phrase introduced by the American scholar and advocate Sandeep Vahizan. Sandeep Vahizan says, 2 and 3 are nice, but not enough. He says you need a root and branch transformation that involves a much more comprehensive reassessment of what all of us should be trying to do with competition law. It's not enough to take the house and add an extension, or to go into the house and add a new kitchen, maybe new floors. The root and branch group says, tear it down, build a better foundation, and construct an entirely new framework. This last group is often called the Neo-Brandeisian movement, and its main critique of mainstream US antitrust policy basically takes policy since the mid-1970s and says, what used to be a good system has simply gone off the road into a trench. I'll say a bit about what its impact has been and how this vision for transformation, which is stimulating the debate today, is likely to have success in the future. Here are 2 people associated with the Neo-Brandeisian group. One is Barry Lynn, who in some ways is the organizer of this group. Barry started writing major pieces about excessive concentration of wealth and its effect on society 20 years ago. One of his proteges is the woman on the other side of the slide, Lina Khan. She is newly appointed to the law school faculty at Columbia in New York, but she has been the counsel, the driving force behind the hearings that took place before the House Subcommittee on Antitrust, Commercial and Administrative Law, and she is the principal author of the report that body issued a week ago. She is the formative influence behind this process. I believe Lina is barely 30 years old. I think it is fair to say that no person so young in the history of US competition law has had such a powerful influence on the debate and the direction of policy. It's an astonishing story. And for our more junior attorneys and economists, if you wonder whether you have to be 60 years old to make a difference, Lina's experience says not at all. Half that age will do the trick. What is the critique of the transformation group? One is that the goal framework established in the late 70s and carried forward is all wrong, that the focus on consumers is misplaced, that we need a broader concept of citizen welfare that looks at the application of competition law to protect the interests of workers, SMEs, local communities, and the health of the economic ecology, and indeed democracy itself. That antitrust law, competition law, should not narrowly be seen as a way to give citizens a better deal in their capacity as consumers. We need a broader view of welfare that encompasses all of these interests. And that is the point on which the root and branch group disagrees with the other groups. The group that wants to do more with what you have or add new tools is operating within a consumer welfare framework that focuses on price, output, and quality effects, innovation. Root and Branch says, too narrow. You need a broader perspective that takes account of these other values. And they have attacked the tendency of US courts since the late 1970s to replace strict rules of prohibition with lenient, permissive rules that govern the behavior of businesses, especially large firms. And they especially attack the development of very complex economics tests to evaluate behavior. They are harsh critics of the modern world of economics. And their view is that economists, in many ways, have hijacked this system of law in the United States. They've stolen it by saying you can't rely on clear rules. You have to look at the universe and all it contains. You have to look at guppies and uppies in order to evaluate market power. You have to hire a parade of experts to tell you what to do. And yes, they raise their hands and say, I'm willing to be one of them. But instead of having clear, bright line rules based on structural tests, focusing on market shares, we have sold out the system to extremely complex, fact-intensive, expensive methods of analysis that tend to favor defendants. They want to replace all of that. Burn it down, build it back up. They also attack the institutions of public enforcement. The Department of Justice Antitrust Division and the Federal Trade Commission are often said to have been captured by big business. And it's supported in the United States by a revolving door that takes high-level officials from the private sector into the agencies. They spend a couple of years and then go back out and make a lot more money. And that this process makes the agencies timid. It creates a culture of restraint rather than aggression. And that the courts also have been captured in their own way by principles that favor economic laissez-faire and disfavor regulation. This, in turn, knowing that the courts are cautious and conservative, makes the agencies even more risk-averse. When you look at internal records surrounding the FTC's decision in January 2013, this is during the Obama administration, the decision not to begin a case against Google, you see a deep-seated risk aversion. You see pro-enforcement minded officials saying, oh, I think we've got a case. I think we've got some good ideas, but we're going to lose. We have some promising ideas, but it will be hard to prevail. And throughout their discussions, you see an element of caution, anxiety about losing cases, and ultimately a decision in Google to stand aside. The Root and Branch Group also does not trust what I would generally describe as us. It doesn't trust the private bar. It does not trust private economic consultancies, and it does not trust bar associations. It does not trust journalists and publishers. It doesn't trust academics. Because the view is they're all part of a racket that wants activity, but wants the government always to lose. That the perfect mix is lots of government cases that always fail, and a government that keeps bringing those cases in order to keep all of us busy, keeps the lawyers with cases, keeps the consultants with cases to work on, keeps law professors with textbooks to write, lectures to give. And professional bodies, such as the American Bar Association, the International Bar Association, are said to be complicit in this by creating a set of norms and culture that want activity, but very limited zone of liability. So the message to agencies is, yes, bring cases, but lose them. Bring cases, conduct expensive investigations, but don't bring a case you can win. Because by and large, we think you shouldn't win. So what do they want to do about it? Change the goals. No more consumer welfare, but citizen welfare, broadly defined. Let's bring back structural rules, strict ones dealing with abusive dominance, mergers, vertical restraints. For horizontal cooperation, relax controls for small firms. Create exemptions, allow gig workers to agree without the benefit of a labor union through loose associations to establish wage levels, and leave occupational licensure alone because it often protects society. Bring back strong sectoral regulation. Part of the argument is that the deregulation movement, the liberalization of industries over the last 40 years in so many of our countries was a mistake. Bring it back. Create new regulatory tools for the digital sector, ex-ante regulation, rulemaking, and at the enforcement agencies, clean house. Too many of the managers have been bitten by mosquitoes so often they don't know that they have malaria, but they do. They're sick. Get the sick, timid people out, bring back, and restore an element of aggression and toughness that doesn't say, oh God, I'm going to fail, but says, I ought to try to succeed. Charles Lindbergh in 1927, they say, did not stand on the runway at Long Island and say, oh my God, go to Paris by myself? I'll run out of gas. I haven't slept in a day. I'm going to fall asleep. There are trees at the end of the runway. It's raining. The runway is soggy. My plane has too much petrol in it. I'm not going to get even beyond Long Island. I'll never make it. No, what did Lindbergh say? I'm going to Paris. And that has to be the attitude of the enforcement officials. We're going to Paris and we'll make it. As a result, you need completely new agency leadership. You need leaders who are committed to the egalitarian vision, that repudiate consumer welfare. That would be the interview question. Are you for or against consumer welfare? Correct answer is wrong standard. We need a broad definition of who's protected. And no contamination. The root and branch group has contempt for Clinton, Bush 1, Bush 2, Obama, and Trump because they didn't do nearly enough. And this group especially has contempt for President Obama, whom they think promised the world, but could not even deliver Kansas City. He said, I will give you the universe, but could not even give you Kansas City because he didn't bring the big tough cases. So the rule is, if you are currently engaged as a law firm partner, if you're an economic consultant working for big companies, if you're an academic who has taken money from big companies, you will not serve in the new world. You're out. And what they have done in many articles is that they have prepared lists and published lists of the people they never want to see again, with little biographies identifying the previous tainted experience. And they say, if any of these people show up in the agencies in the future, you will know that agency is sick and isn't going to do the job. That's what root and branch transformation means. Burn it down, build it back up. They've been really influential. They've changed the debate. You can't go to a conference now without these ideas being front and center on the agenda. They've changed what people are writing about. They have attracted a new generation of young scholars who only write about this. And in many instances, come up with still more creative ways of putting it in place. They have put the traditionalists and the mainstream defenders on the back foot. And it has been so powerful and so sudden, basically it's happened in 5 years, that the traditionalists still don't know what hit them. The traditionalists are lying on the street, looking up, trying to get the license plate number of the truck that ran over them. It happened that powerfully and that suddenly. And they've had the ear of the Congress. The report that was issued last Wednesday that has become a global focal point for discussion. That's all root and branch. That's their work. Because Lena Khan, whom we just met there, because Lena wrote it, and Lena persuaded the members of the committee that that's the way competition law should go in the future. Root and branch. The report came out last Wednesday. Long report, but very interesting reading. Those of you who have a special interest in digital markets will find the 200-page discussion of each of the four leading platforms: Google, Apple, Facebook, Amazon. You will find it very interesting reading. Even if you don't agree with it, they've done quite an effort to describe how these business models operate. And for that reason alone, it will be much read, and they will have influence for that reason. I want to give you an idea of how the tone of the debate changed and what they have in mind. This is a quote from the beginning of the report. Nearly a century ago, Supreme Court Justice Louis Brandeis, Neo-Brandeisians, that's what they call themselves. Louis Brandeis wrote, "We may have a democracy, or we may have wealth concentrated in the hands of a few, but we cannot have both." Those words speak to us with great urgency today. What's at stake, are they saying? The democracy itself. It isn't a matter of goods costing a little too much or not being high enough quality. What's at stake is democracy. It has been 45 years in the United States since a legislative committee wrote a document that way. 45 years. You have to go back to the mid-70s when many of these ideas enjoyed great popularity before. At the end of the report, the subcommittee recommends that Congress consider reasserting the original intent and broad goals of the antitrust laws by clarifying that they are designed to protect not just consumers, but also workers, entrepreneurs, independent businesses, open markets, a fair economy, and democratic ideals. How many conferences in North America would one have gone to even 10 years ago where a speaker would say, competition law should protect a fair economy? Fairness, to even mention what's fair, was seen as introducing a completely empty-headed concept. Oh, that's not fair. That's what a small child says in playing football when they're tackled hard. That wasn't fair. For years, the referee in the United States said, get up and play. I'm not going to call a foul. This report says it should be fair for workers, entrepreneurs, independent businesses, open markets, and democratic ideas. What specifically does the report propose? It tells the agencies, you failed. You failed badly in the last 40 years. You especially failed in the last 10 years. Do your damn job. Bring big, tough cases against big, tough companies. The report is also saying, oh, you're saying you're going to lose? We don't care. There will be a benefit from simply being in the match. You can't possibly win the match unless you play. So play. Surprise yourself. If you lose, we will try to get you better players and maybe change the rules that make it easier for you to win. But play. In addition, we're going to change the laws. We are dramatically going to change the U.S. statutes. There is a list of about 12 cases decided by the Supreme Court, one by the lower courts, they list in the report, and they say, these will go. We will have a provision in the law that says these precedents are dead, no longer valid. They're going to change the rules. And they're going to build in specific prohibitions to deal with mergers and dominant firm behavior that create presumptions based on market share and the simple fact of behavior that take merger control back to an era when much smaller mergers were prohibited out of hand, and vertical mergers were routinely prosecuted as well. One of the structural presumptions will be if you are a large enterprise, a dominant firm, you will not be permitted to buy any nascent competitor, no small enterprise that does or could compete with you. Complete prohibition. And they say, let's create new regulatory tools. We want structural separations. We want to tell Amazon, you have a choice. You can run the platform and be the conduit to sell things through the platform, or you can run your marketplace where you sell your own goods and services. You cannot do both. You, Amazon, cannot sell your goods and services on your platform. Forbidden, categorically. The new regulatory mechanism that's suggested would put that restriction and others in place. Who would receive this mandate? Not clear. But it would be a regulatory process that involves adopting binding rules that set standards of conduct and in some instances require the breakup of industries. How did they become influential? Well, the traditionalists became smug and content. You can look at some commentators who've said in the last 10 years, the debate's over, we won. Consumer welfare forever. All of these other goals, egalitarianism, small firms, entrepreneurs, fairness, democracy, workers, nobody takes that seriously. They're very satisfied with what they'd accomplished. They themselves had been revolutionaries in changing the framework. And they looked at the Neo-Brandeisians and said, who on earth are these people? Lena Khan wrote the article that triggered the modern discussion in 2017. She was in law school. It was her last year of law school. And many traditionalists, much older, said, who ever pays attention to an article written by a law school student? They're children. They don't know enough. We are the experts. So maybe you pat the student on the head and say, go over and sit with the other children. Leave us alone. We're the adults sitting at the adult table. And there was not much awareness on the part of how systems change and what causes them to change over time. I guess a lesson for life is to realize, one, it's never over. There are no final victories. And the moment that you think you have achieved a final victory is the moment that you have planted the seed for your future failure, because someone will knock you over and you'll never know what hit you. There were powerful external economic shocks. The modern environment in so many ways is a product of the GFC 10 years ago. And the current COVID crisis is reinforcing some of that anxiety. Starting at the beginning of this year, and I say 202 question mark, who knows? What did these shocks do? Tremendous economic upheaval that created huge social misery. Anxiety, doubt, fear, a tremendous distrust of capitalism related to the GFC. That is, what were you businesses doing, turning your banks into casinos? Real doubts about global economic integration. Global supply chains used to be thought of as good, positive. Today, bad, dangerous. And a complete loss of confidence in public administration, especially in 2008 to 2010. Where were the regulators? Where were the banking regulators, the financial service watchdogs? What were you doing except telling us it's all okay? These risky financial instruments, the risk has been distributed. These shocks created an environment where new ideas became welcome. There's a big fight going on now in the Joe Biden, Kamala Harris camp. And the big fight is between the do more with what you have or do more with what you have plus add regulation on the one hand, and root and branch transformation, who's going to win? There's a big battle going on between those two groups. As vice president, Joe Biden during the Obama administration and Kamala Harris when she was the Attorney General of California and US Senator, they've been pretty friendly to big tech. They didn't do much to this point in their lives to threaten them. There's nothing in their background that says they would do the big root and branch transformation. But who knows? Who knows? Senator Elizabeth Warren, Senator Bernie Sanders, and like-minded legislators are the ones who are pushing for a fundamental change. The team that the Neo-Brandeisians are very strong Biden supporters. If you look at lists who have attended fundraisers for Biden-Harris from the antitrust community, it's all of the people who have been said by the Neo-Brandeisians to be illegitimate because they had the jobs before it and didn't use them. If Joe Biden wins in the period between early November and January, who wins this fight? One side, the other, or will we see a compromise? Or you will see a mix of both coming into the new administration? And this would be the question to pose to Biden and Harris. Here again is the House menu. Big cases right now, amend the laws and create a new framework. Here's the question to Biden and Harris. Would you accept that package? Do you endorse it? If I could ask a question at any future debate that takes place, I'd say, Mr. Biden, Ms. Harris, do you embrace that program? Is that your program? Would they say, yes? That would be telling. Will they say, oh, it's interesting. Everything is on the table for discussion. Or will they say, I don't want the prix fixe menu. I want to order a la carte, selected pieces. And do they say, let's see how the existing cases go? It's hard to tell. One thing for you to watch. Here are two people who might be appointed to big jobs. Terrell McSweeney is a former aide of Biden's, worked in the White House with Biden. She was an FTC commissioner during the Obama administration, and she is now a partner at Covington, representing big bad firms. Rohit Chopra is currently an FTC commissioner. He's a vocal advocate for doing much, much more. He used to work with the Consumer Financial Protection Bureau, and he is a protege of Elizabeth Warren. They might both be candidates to run the Federal Trade Commission. Who's going to get picked? If it's Chopra, that's a message to be much more aggressive. If it's McSweeney, it's a message to be somewhat more aggressive. Do both of them show up in top leadership at the public agencies? That's the debate that's happening right now in the United States. Let me give you a quick timetable about when legislation might be adopted. Let's assume for a moment that the Democrats succeed gloriously in early November. It's 3 weeks away now in the United States. They win the presidency and they control the Congress, both the House of Representatives and the Senate. So that's my assumption. As a benchmark, when Congress adopted the Dodd-Frank financial services reforms, it took 18 months from the beginning of the Obama presidency until it was adopted. That's a year and a half for legislation that responded to the near disastrous collapse of the US financial services sector. If it took that long to do Dodd-Frank, one way of looking at this is you're not going to get a new law until maybe the middle of 2022. What strategies will the law-making proposals pursue? Will they say, take one piece, let's do mergers first? Will they say, no, try the whole agenda, the entire menu from the House report? If you took one piece, maybe you get one piece through in 1 year, so that in early 2022, maybe you have your new merger law. I think the lesson here is that if you think of litigation and its role, it's probably going to be the main tool for change for about the next 2 years. That a new law that creates a new environment would probably not be adopted until early 2022, or maybe the middle of 2022, or late 2022. So if you're going to do something for the next 2 years, you're going to have to do it by bringing cases under the existing law. Oh yes, judicial appointments are part of it. Trump has appointed about 25% of all federal judges who serve right now. Judge Amy Barrett is the nominee to join the Supreme Court, and Trump, if she is confirmed, will have appointed 3 members of the Supreme Court in his 4 years. So the majority with Judge Barrett, she has not been approved yet. She finishes her hearing, I believe, today in the Senate, will be 6. Roberts, Alito, Barrett, Gorsuch, Kavanaugh, and Thomas, 6 of the 9, they're all skeptical of economic regulation. They are not nihilists, but they are skeptical. If you are an enforcement authority or a plaintiff in a private case looking at those people sitting on the podium in front of you, you realize this is a tough fight. It's not hopeless. It's not welcoming. A Biden presidency will result in the appointment of more judges who are more favorable to economic regulation, but it takes a while to get them on the bench. And this right here, that court majority, they're not going to change that right away. If these people are healthy and they stay around for a while, they could very well be facing any plaintiff who comes up in the next 4 years. We turn to some matters of doctrine. First, some thoughts about developments involving the filters that determine whether you get into court, especially as a private litigant. One popular technique in the United States in the last 10 years has been to require consumers and customers to sign arbitration clauses. These clauses say, if you have a dispute with what I, the seller, have done, we will first use mandatory arbitration. We'll talk later about whether you can go to court, but the first thing you must do is to go into arbitration. These were challenged in a number of cases saying, what? You know, with a mandatory arbitration clause, I'd lose my right to bring an antitrust case immediately. The court so far have said, yes, that's right. The House subcommittee says, we're going to eliminate these. We're going to invalidate them. We're going to say you cannot sign away your right to go directly to federal court and bring antitrust cases. But at the moment, that filter's in place. The House subcommittee wants to take it away. Another filter that's over 40 years old is called antitrust injury. It means that if you want damages or an injunction, you have to show that your harm, your injury, results from harm to competition, not just a loss of profits for yourself. The plaintiff in Brunswick operated a local bowling alley. Brunswick, the defendant, acquired a failing bowling alley that was their competitor. The plaintiff challenged the merger and said, here's my theory of harm. If Brunswick had not performed this acquisition, that company would have failed. And in that community, there would have been one bowling alley, me. And I would have been able to charge monopoly prices. So my measure of injury is monopoly prices minus competitive prices equals damages. That's what I want. And the Supreme Court said, let me understand this. You're claiming as injury the loss of monopoly profits. The plaintiff said, exactly right. That's it. The Supreme Court said unanimously that can't be right. That cannot be right. Antitrust law does not give you a property right to monopoly profits. It doesn't do that. And it says your injury must be related to behavior that reduces competition, doesn't increase it. The House subcommittee in its report says Brunswick is going to go. We will repudiate Brunswick to change completely the notion of who is protected with what kind of remedy, with what kind of injury. A small company like the plaintiff in Brunswick might get recovery for its loss of monopoly profits when its opponent is a big national enterprise, which Brunswick was. Standing, especially for indirect purchasers. To go back to that famous US year of 1977, the Supreme Court said indirect purchasers do not have standing in federal court to bring damage cases. If you're not the direct purchaser, no standing. Earlier this year, in Apple versus Pepper, the Supreme Court, or I should say 1 year ago, it's 2019. In Apple versus Pepper, the Supreme Court said that the challengers to Apple's behavior on its platform had standing. The companies in Apple, the defendant was Apple. Apple had imposed charges on apps developers that use the platform, a 30% surcharge to certain app developers. Purchasers of those apps sued Apple. They didn't sue the app developers. They sued Apple and said, you caused this injury. You imposed the surcharge. You imposed the restrictive conditions. Apple said, you're not the direct purchaser. You bought your app from the app developers. If you want to sue somebody, sue the app developers, but under federal law, you can't sue me. The Supreme Court said, yes, they can sue you. They can. You're the cause of the harm. You caused the injury here. And yes, there are app developers, but there's no question that you're really controlling this entire commercial model. You are responsible. And the author of the opinion was Justice Kavanaugh, who's not a big fan of competition law. And he writes glowing tributes to the purpose of the antitrust laws. So the ban on indirect purchasers standing could be eroding. The court said, we have not eliminated the rule of Illinois BRIC. In some ways, they have been. So the litigation filters may be at risk. Limit on indirect purchasers may be eroding if there is new legislation. The arbitration clauses in the antitrust injury requirement probably both disappear. I want to talk about agreement issues now, to talk about three. To talk a bit about American Express and two-sided platforms, the Apple eBooks case, which continues to have a lot of influence, and activists and pay for delay in the pharmaceutical sector. Just a quick primer on the framework of agreement issues under Section 1 of the Sherman Act. These are the equivalent of issues under Article 101 of the Treaty on the Functioning of the European Union. What's the basic analytical tool? It's what's called the rule of reason. And its main purpose is to identify actual or likely competitive effects. The analytical process begins with what's called characterization. That's where the court, since 1979, has said, when you have this framework with different options, you have to start at the beginning by saying, where does the behavior begin? How do you classify the behavior? Where does it go? Into what basket would it appear? Where do you put the conduct? One place is to say it's per se illegal. That is, it has no purpose or possible effect other than restricting competition. Horizontal price fixing, horizontal output allocation, allocation of customers, allocation of territories. All condemned out of hand unless you have a powerful efficiency justification. The justification that avoided condemnation in BMI was to show that it permitted the creation of a new product or service that would not be available without a price restraint. In most cartels, no such justification exists. So is there a per se rule for a lot of behavior? Yes, there is. The second closely related test is called the quick look. If the behavior closely resembles behavior that has been called per se illegal, the burden will shift to the defendants to come up with an efficiency rationale. If they can't provide it, the inquiry stops. If they can, the inquiry is more elaborate. But the quick look is designed to assist the plaintiff in eliminating the need to show market power. And the third approach is what's called the full real review. You could introduce direct evidence of adverse effects, but often the method is to show circumstantial evidence, which is to prove market power plus conduct that has any competitive features. That's the menu under the rule of reason. Credit card systems have become an important area in which this has been tested, and the American Express case of a couple of years ago is still the much debated and formative case. American Express, and one of the named plaintiffs is Ohio. It's often reported as Ohio versus American Express, is an example of a two-sided platform. It's a payment system. On one side of the platform, the payment system, you have card users. On the other side of the platform, you have merchants who accept the card. And the company that owns the card has a decision to make. How much do I charge each side? I can charge my card members a higher fee to hold the card. I can charge merchants more to process transactions. In this case, the merchants were bound by a contractual requirement with American Express that said, when customers come to you to pay for a product, you cannot try to identify other cards that are less expensive to use than mine. The commission that American Express charges is higher than that for, say, Visa or MasterCard. Without these contractual provisions, which are called no steering rules, if you came up to me and pulled out this card, I would say, Bruno, do you have a Visa or MasterCard, Bruno? If you use this one, if you use that green card, you're going to pay more for this transaction. They charge me a higher commission, so the purchase price is a little higher for you. You have to pay for that. If you have Visa or MasterCard, the commission is half as much, and I'll give you a better price. So if you've got a Visa or MasterCard, give me that. You pay less, I pay less, we're both better off. How about that? The no steering rule says you can't say that. Bruno pulls out the American Express card, and I'm silent. I don't tell him that there's a better opportunity for him and maybe for me. I'm silent. The Department of Justice, in litigating its case, showed an adverse impact on prices on the merchant side of the platform and said this was bad for consumers. The merchant couldn't tell them valuable information relevant to the transaction. Consumers paid more as a consequence. And the Department of Justice said, that's the harm right there, competitive harm. Clear direct evidence of adverse competitive effects, we win. The Court of Appeals and Supreme Court said, not so fast. No. This is a two-sided platform. And the merchant side may have some adverse effects, but there are positive effects for card members. They get points, they get gifts, they get concierge services, they get a better seat in the lounge at the airport. They get all kinds of benefits from American Express because they own that. So to know the real competitive impact of these provisions, you have to measure the effect on the merchant side and the effect on the card member side and balance them to come up with the net effect. And you didn't do that here. This finding of liability is dismissed. The court also says in American Express, the quick look that we were talking about back here, this quick look, that's only available in horizontal restraints cases, where the challenge is to behavior involving rivals. because all of the Supreme Court's cases that approved the quick look all involved horizontal restraints. And we know the Supreme Court says that vertical agreements are quite often pro-competitive. So no quick look. Now in all of the Supreme Court decisions that approved the quick look, the court never ever said, by the way, you can only use this tool for horizontal restraints. Only. Never bring it up in a vertical case. Court didn't say that. It said it here. No quick look for vertical agreements. Full rule of reason. No quick look shortcuts. The implications of this case have been broad. The argument that platform owners in a variety of situations are raising is you don't know the adverse effects unless the plaintiff has introduced evidence that looks at both sides. That's a more complicated case. The balancing itself may be harder to do. Defendants are raising this in merger cases now. And a whole variety of companies are saying, I'm a platform. I am a two-sided platform. And there are lots of two-sided platforms. And the concern is that this decision turns lots of antitrust analysis into a two-sided platform analysis, including abusive dominance cases. If you're thinking about a possible lawsuit in the United States against Google, Amazon, Facebook in particular, what will be one of their favorite cases? This one. Because they'll be saying, you have to examine the competitive effects on both sides of the platform before you draw any conclusions at all about competitive effects. Deeply influential. The House Judiciary Committee has said, that case goes. If we get our legislative proposal approved, that case is invalidated. That precedent will be expunged to establish the principle that effects on one side are enough. You have proof of harm on the merchant side, that would be enough. The House subcommittee report says there was liability there, and that case will be decided differently in the future. American Express is one of their main targets. US v. Apple has been interesting in that it highlights the role of platforms and the interrelationship between upstream and downstream firms in cartelization agreements. This involved ebooks. The principal actors here are book publishers who are facing Amazon, which is charging $9.99 for electronic books. The publishers don't like this because if you can get the ebook for $9.99, there are a lot of people who will not buy the hardcover for $20.99. All the traffic will go towards ebooks, and hardcover sales of bestsellers in particular will diminish, and those are a major source of revenues for the publishers. So the publishers hated this. They hated Amazon's $9.99 policy, but because Amazon accounted for over 90% of ebook sales, they said, we don't have a choice. They met regularly and said, let's raise the price from $9.99. How do we do it? Don't know. If we try to do it, if we resist, Amazon's going to go to the weakest one of us and say, I'll crush you if you don't get in line. I'll destroy you. I'll destroy you. If you try to withhold your electronic books unless I raise the price, I'll go to everybody else. Apple comes forward with the iPad and says, we want an electronic library that will include the books you publish. We want that on the iPad. We also want to enter and compete against Amazon with respect to this function. And we do not want to charge $9.99. We like $12.99 better, at least. So we're with you. We want to raise the price. We want to enter. Here's an idea about how to do it. Okay, we'll all agree with the new prices, $12.99. How to deal with Amazon? Well, what you are going to do is change your distribution model. Right now, you are simply selling the electrons to Amazon, and then Amazon resells them. We're going to change that transaction to what we call a consignment. That means you do not sell Amazon the electrons. No. You consign them to Amazon in the way that a painter uses a consignment agreement to deal with the gallery that displays the painting for sale. Sotheby's, for your portraits, the portraits you do in your spare time, Sotheby's usually does not buy the portrait. Sotheby's agrees to display the portrait, maybe to auction it. And your contract with Sotheby's says, if you sell my painting, you get a percentage of the sales price, but it's still my painting. And I can tell you the minimum price below which you shall not sell the painting. If I think the painting is worth $1,000 and someone comes in and says, that's a nice painting, I'll give you 100, I can give you instructions not to sell it for 100, only 1,000 and up. So Apple says, that's what we'll do. You go to Amazon now and say, we are no longer going to sell you the electronic books. We are going to consign them to you, all of us, and we will dictate the price below which you cannot resell. But what happens when Amazon turns to us and says, I'm not going to do that. I'm going to give you no business, and I'm going to go back to the others, and I'm going to tell them, I'm not accepting this arrangement. We're doing business on the old terms, and I will not work with the people who want to make this switch. And I'll see who's willing to cave in. Apple said, we have a solution. It's going to be called the Most Favored Nations Clause. It goes like this. If I, Apple, see any of you selling, if I see Amazon for any reason on earth selling your first edition ebooks for $9.99, I'm going to go down to $9.99 as well, and I'll stay there. I will only stay at $12.99 if Amazon is unable to sell at $9.99. And that tells all of you, if any one of you caves in, the whole deal is off. So I've helped you organize the cartel and enforce it too. The district judge found an infringement, and so did the Court of Appeals. And one issue for the Court of Appeals was, oh, wait a minute. Yes, the publishers are agreeing, but Apple is vertically related. They're not a competitor. They're not part of a horizontal conspiracy. The Court of Appeals said, oh, yes, you are. Sure you are. You're the hub that is organizing the behavior of the spokes. This is a horizontal conspiracy. It's per se illegal. You are the facilitating mechanism. And Apple then said, okay, I've got one other argument. This agreement facilitated new entry. Before the agreement, there was Apple and Pygmies. Now it's Apple and Amazon and Pygmies. Now it's Apple and Amazon. Yeah, the price will go up for a while, but over time that will come down. So who are you rooting for here? Are you rooting for the monopolist? Amazon would love for you to invalidate the agreement. Or are you rooting for entry? The court said, nice argument, but if you're posing that choice to us, we do not want entry at the high price you're going to charge. The real benefit to consumers here is the low price that they're getting from Amazon. If you ask consumers, would you rather, here's the electronic book. Here you have a choice, consumer. Would you like to pay $9.99 or $12.99? This is not a trick question. Most consumers will say, $9.99. Yes, that would be less. The court said, that's whose interest we're protecting here, even at the cost of not having entry. Two more modern horizontal restraints cases. One involves reverse payments. This battle goes on. These involve, in the US context, the consequence of a statute called Hatch-Waxman, which is designed to encourage the entry of producers that offer generic equivalents of branded pharmaceutical products to either come in with a non-infringing equivalent or to attack patents that are thought to be deficient. What starts happening in the operation of the statute is that entrants come in, the branded incumbent sues them for infringement, but then after some time says, let's settle the case. And when they say, let's settle the case, okay, I'm the alleged infringer. Okay, here's my checkbook. How much? The branded firm says, put that away. Say, what? You want a settlement? Well, usually the settlement of an infringement claim involves the infringing party paying a settlement amount to the patent holder. Well, how much? Patent holder says, no, it's different. Put the checkbook away. Okay. What's the deal? I'm going to pay you. I have my checkbook open. I'm going to write you a check. One catch, though. You're going to agree to delay the point at which you come into the market. So you stay out for a while. Most of the courts of appeals looking at those agreements said they're acceptable. The FTC, in a series of matters beginning in the late 90s, said no. If they are not illegal per se, they're very close. That's a payment to retard entry and nothing more. Most of the lower courts said it's acceptable if you take the length of the patent, assuming that the patent holder can demonstrate that it is valid, say in an infringement case, you take the length of the patent. If you sign an agreement that identifies when the other producer can come in the market, as long as it is short of the length of the patent, it's acceptable. It's acceptable. You don't have to license anybody. If you decide to let them in for a period, again, that takes place before the patent expires, that's better than denying them entry at all by not giving them a license. You cannot limit entry to a period after the patent expires, but you can certainly limit entry to a period before the patent expires because that's within the scope of the patent. Legal per se. The FTC takes a case to the Supreme Court, and in a case called Activists, the Supreme Court says there is no presumption of legality based on the scope of the patent. The rule of reason controls. The FTC had said, we're glad for that. At least it's the rule of reason and not complete legality. Thank you. We'd like something more, though. We'd like a presumption that the behavior is illegal. We'd like the equivalent of a quick look here, because if you take an incumbent firm giving a bag of money to an entrant to stay out, wow, that looks dangerous. Patent or no patent. Why should we let that happen? Treat that as creating a presumption of illegality, make it rebuttable, but treat it as being very suspicious. The Supreme Court said, no, we're not going to do that. I think Justice Breyer, who wrote the opinion for the court, wanted to, but he could not get a majority. So he says, we're not saying it's illegal. We're not creating a presumption. Here are some factors that are relevant. One factor is to take the size of the payment from the incumbent to the generic and compare it to the likely cost of litigating a patent infringement case. If that payment is much bigger than the cost of litigation, much bigger, that is a sign that it is likely that it is competitive. Lower court decisions have been trying in a number of ways to apply the Supreme Court's guidance here. A number of them have said that there are a variety of forms of payment, transfers that can constitute payment. One of them is a recent case called AbbVie involving the FTC, where the court said it doesn't have to be a transfer of cash. It can be the transfer of other types of value that constitute the payment for delay. The courts at least have defined the notion of payment broadly. The number of these delay agreements has fallen since Activists because By law, if you sign a pay for delay agreement, you have to give it to the FTC in advance. They get to hold on to it. But given the stakes in these pharmaceutical cases, there'll be continuing litigation that surrounds what kinds of arguments in a rule of reason case are relevant. One other emerging issue before turning to dominance and talking about Qualcomm, employment contracts. A number of companies in the tech sector in the 1990s and 2000s, early 2010s, signed agreements that said, signed agreements or made spoken agreements that said this: let's agree not to make unsolicited employment calls to the employees of each other. Let's not do that. Talent's a valuable commodity. Talent lets you assemble a team that can achieve a breakthrough. It's destabilizing to do that. So I, Bill, cannot call Bruno. Bruno's a competitor. We don't make exactly the same thing, but assume we do. We both make smartphones. I'm Apple, Bruno's Samsung. We don't set the price of this machine. We don't do that. But what we do is to say, I know that we have a habit now and then of making a phone call to a young software engineer with each other's company and saying, you want to switch? Let's stop that. Don't do that. You can place an advertisement in a newspaper, in a magazine, online. You can put a billboard outside the front of your competitor's plant saying, come work for us. But you can't make the phone call. No unsolicited phone calls. The Department of Justice signed a settlement agreement with a large number of Silicon Valley tech firms in which they said, well, stop it. We won't do it anymore. The DOJ and the FTC then issued a policy statement saying, we will treat this as a per se illegal offense if we catch you again. And the Department of Justice said, even more, if we catch you making these agreements in the future, we will try to put you in prison. None of those cases has been brought yet. There's never been a criminal challenge yet to one of these agreements. But DOJ and the FTC have said, we will treat them as very serious infringements, and DOJ has said, we will try to prosecute those as crimes. The other are non-compete agreements, where employees sign agreements that say, when we leave our employer, we will not go to work for a certain period of time to a competing firm. There's a great deal of litigation now, private litigation in the federal and state courts, challenging non-compete agreements as anti-competitive under Section 1 of the Sherman Act or the equivalent provision of state law. No clear results at the moment. These, again, have been suggested as focal points for legislation to simply prohibit them. And there's been some discussion at the FTC about possibly considering adopting a rule that would render non-compete agreements to be illegal in a number of circumstances. So, two agreement issues on the frontier. And again, the Neo-Brandeisian movement is giving a push to this by saying, who suffers here? Workers. Workers are the victims. They are denied a fair competitive wage. And that's why these cases deserve a lot more attention. There aren't major recent cases that deal with how you define agreement, but the existing Supreme Court jurisprudence, Matsushita and Twombly, both impose fairly demanding standards on plaintiffs in seeking to plead the fact of concerted action. It says that ambiguity favors defendants, and it tells plaintiffs, even at the point of drafting the complaint, you have to give us enough facts that make the existence of a conspiracy plausible. Doesn't have to be probable, plausible, and it cannot merely be possible. Those are hazy standards, but both of these decisions placed a greater burden on the shoulders of plaintiffs and provided a rough signal to courts If you want to aggressively throw these cases out because you think the evidence isn't strong enough, we will support you. The House Subcommittee report says both of these decisions will go. They will go in the rubbish bin if we adopt comprehensive legislation because they make it too hard to establish the fact of agreement. Dominant firm behavior. The modern context is very pro-defendant in the United States. The jurisprudence is very sympathetic to defendants. Predatory pricing. The plaintiff has to show pricing below some measure of cost and recoupment. It's not enough that you prove that the incumbent responded by selling its prices well below its variable costs. You have to show that once you were excluded or chastened, it was not possible for other firms to come in and compete the price down to a competitive level. That if you're the plaintiff, you have to show, one, the defendant had market power. Two, they set their price below an appropriate measure of cost. That probably means variable cost. And three, the market conditions are such that the defendant's going to get its investment in predation back and much, much more. The object of the rule in the eyes of the Supreme Court is to protect consumers. So that if I say, wait a minute, I had great promise as a new entrant. I was a very, very innovative and promising new company. All I needed was experience. And the defendant crushed me as soon as I came in. I never got a chance to achieve appropriate scale, but I had a great idea and I was destroyed. The Supreme Court's reaction is too bad. Unless you can show us that your destruction hurt consumers, we don't care. And from what we can see, the defendant's never going to be able to raise its price or otherwise reduce quality. So your disappearance is a shame. And I say, I just want to try this once more. I'm an innovative entrant. I have the potential to be more efficient than the incumbent. I've got new ideas that the incumbent doesn't have. If I only get a chance, I'm going to be giving consumers probably better prices, better quality. And they destroyed me. So my injury is important. The Supreme Court's view has been, not to us. Too bad. You come back and show us that recoupment is feasible, then we're listening. Otherwise, we don't care. The Neo-Brandeisians say, yeah, we care a lot about that entrant. The House Committee report says Brook Group is gone. We'll destroy it. Refusals to deal, Trinco. Dominant firm generally has no obligation to deal with anyone it doesn't want to deal with, including a non-integrated entrant. Doesn't have to do it. No general obligation to deal. House Committee report says that case goes too. We don't like Brook Group, we don't like Trinco. That's wrong with U.S. antitrust law. And Trinco has a long testimonial to the benefits of monopoly pricing as an inducement to enter markets. It has a passage that says monopoly can really be good because it gives an incentives to other firms to come in the market. Again, given the view of the House Committee report, that's another reason that case is out of here. A case that the pro-enforcement group likes, that's Microsoft. Microsoft does say there is a danger to dominant firms in U.S. jurisprudence. What's the high ground? The plaintiff shows that the defendant demanded exclusivity as a way of keeping it out of the market, usually keeping it out of the market by increasing the cost of a vital input or making a vital input available only through an inferior source of supply. That's what the US government said Microsoft did in order to keep out threats from the browser Netscape and to disadvantage Netscape in turning into an alternative for Windows. So the cases that plaintiffs have won have usually alleged some form of exclusive dealing. Again, the House subcommittee report, we like Microsoft, but Brook Group Trinco, they go. The new law obliterates them. This is my last main example. This is the most important abusive dominance case running in the United States today. It's FTC versus Qualcomm. If litigation is going to be the path to success, this is the case that more than any other tests what you can do with litigation. The FTC brings this case challenging Qualcomm's practice involving the licensing of its microprocessors. Qualcomm chips are all over these machines, all over them, inside. Qualcomm chips do a number of things. They allow one system to talk to another. So you have an Android phone, you're talking to an Apple phone, they can talk to each other because of a Qualcomm chip. Qualcomm microprocessors provide the mechanism for doing 2G, 3G, 4G, 5G. The typical smartphone uses Qualcomm chips. They're the leading producer of chips used in handsets. The FTC says that Qualcomm did the following. One is, if you use our chips, you pay us a licensing fee. No surprise. What happens if I also use somebody else's chips? The FTC said, what you're doing, Qualcomm, is saying you're going to pay a higher licensing fee. That is, one fee if you only use our chips, a higher fee if you use someone else's chips in addition to our chips. So if you want our chips at the lowest royalty rate, don't use anybody else's chips. No AMD, no somebody else, no. The FTC said, in effect, two problems with this, just to identify the theories. This is like exclusive dealing. This is an exclusivity contract that punishes people for using the product and input produced by someone else. This is designed to make sure that competing chip manufacturers cannot deal effectively with original equipment manufacturers who are their natural customers. So this makes it harder for other chip producers to get a foothold in the market and expand, and the result is higher prices for chips. And it means that those of us who buy these pay a higher price. So who's the ultimate victim? Smartphone users. The district court also says this is an illegal refusal to deal. That the condition that you're imposing on purchasers of smartphones to get your chips, if they use the chips of competitors, is basically inducing them to refuse to deal with other chip producers. And you yourself, in effect, are saying, if you do not deal with me on these terms, I will not give you chips. The district court, the trial court in California, federal court and trial court, agreed with the FTC, both on the refusal to deal theory and the exclusive dealing theory, and imposed an injunction on Qualcomm saying, stop it right now. Qualcomm appealed to the Court of Appeals, to the Ninth Circuit, and said, we want an immediate order that prevents the application of the remedy. We want an emergency order that stays the application of the remedy, and we want an appeal. We want you to review the decision of the district court, which we think is primitive and contrary to US competition law, especially this Trinco case. Especially Trinco. We are asserting a broad right to license on our own terms. We're saying this is really just patent licensing. What you're complaining about is the rate that we set for our licenses. We have absolute power to set the licensing rate that we want. The FTC said, no, this is conditional. The rate depends on whether you use the product of a competitor. It's exclusive dealing. It is not just the licensing fee that you charge for your chip. You're really imposing a premium, a surcharge on the smartphone manufacturer that uses another chip. That's illegal. Qualcomm said, no, 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 we're just setting the royalty for our chips. And we have complete freedom to do that. In the appeal to the Ninth Circuit, the Department of Justice, that is the partner agency of the FTC, appeared in court on behalf of Qualcomm. It filed a brief in front of the district court saying, we want to show up and make an argument about the remedy. And in that paper, DOJ said, Judge, before you issue the remedy, be very careful. If you're not very careful about choosing the remedy, you could harm innovation. And we think an injunction is a very bad idea. So in an abusive dominance case like this, a monopolization case, you, the judge, have to be very careful about the remedy and no injunction. The judge at this level, again, the trial judge here, she read the DOJ brief and said, thank you very much for that. Be careful about the remedy. What a great idea. My thought was when I impose a remedy to be reckless, but you told me to be careful. That's a very helpful bit of advice. Thank you so much for telling me to do my job carefully. She didn't say that. She said, thank you. I've read your brief. I am being careful. The injunction sticks. I will give you an interpretation of what she was saying was, get out of here. Get out before I have one of the court officers arrest you and throw you out. Get out. As a judge, I know how to be careful. That's my job. Thank you for stating the very obvious. What you don't like is the result, so you just get out now. They show up in front of the Court of Appeals and say, court, you should review this remedy right now. Stop it, it's a bad idea, because the case is a bad idea. So they go from telling the trial judge, be very careful, to telling the Court of Appeals, she's crazy. She made a big mistake. Stop the remedy. And then the Ninth Circuit says, we will. They do give an injunction against the injunction. And then in the hearing on the merits before the Court of Appeals, the Department of Justice is sitting with Qualcomm, saying we support them. We, the Department of Defense, the Department of Commerce, and us, we on behalf of the Department of Commerce, the Department of Defense, and the Antitrust Division oppose this case. Kill it. It's using discredited old ideas. So the FTC is fighting against the federal government and fighting against Qualcomm. The Court of Appeals, during the oral argument, you can watch the video. Two members of the Court of Appeals very clearly appear not to have any understanding of the case at all. They are holding on for dear life. It is as though the court decided to invite anyone to come in and be a judge for a day, and they were picked randomly for an audience. You want to be a judge? Good, you're on. You're going to hear a case today called Qualcomm. I don't know anything about Qualcomm at all. That's okay, you can be the judge. Two of the judges are completely lost. One of those judges writes the opinion for the panel, and they decide to throw out the district court ruling. One of the remarkable things they say is they don't talk about the evidence that the district judge reviewed. She made very strong findings on the fact that the executives for Qualcomm were lying, were not truthful, and she excluded their evidence. The court doesn't talk about that. The court says, there is a fundamental misunderstanding in the FTC's case and its theory of harm. And it deals with competitive injury. The FTC here is alleging that the victims were mainly consumers of these phones. They don't tell us much about injury to the competing producers of chips. They talk about how the original equipment manufacturers are overcharged, and then consumers are overcharged, but there's no allegation or proof of injury to the competing producers of chips here. So there's no injury. And the court says it is not adequate to just say that consumers were injured. the FTC has filed a motion for rehearing en banc for the whole Court of Appeals. 3 judges decided this. They want the entire court to hear it. Plenary panel. And the FTC is saying there are 3 basic errors. We only have 20 pages. We're just going to make in 3 errors. We could talk about 20 errors. Here are 3. 1, alleging injury to consumers is very much competition injury. How does it happen? We explained how it happened. You tell the OEM that it has to pay a premium to buy the chips of rivals. That means that rivals cannot provide competitive prices. So the price of the input to you, the OEM, goes up, and then you pass it along to consumers, so they pay a higher price. That is how consumers pay a higher price. That's what does it here. The lower court also had accepted the idea that it's a patent. This is just patent licensing, and you can set the licensing fee that you want. Nothing new about that. You have complete freedom to do that. And the FTC saying, no, the licensing price depends on paying. There are really 2 prices here: the license and the surcharge to exclude other chip manufacturers. Those are 2 different prices. It's not just the licensing fee. So the Court of Appeals has to decide whether to rehear the case. That may take a couple of months. And then if the Court of Appeals says we won't do it, or if they reheard the case and they vindicated the panel decision, then the FTC can go to the Supreme Court. Why does this passage of time matter? Because there could be a new president by the end of January 2021. And a Department of Justice that takes a much different view about what issue, about this issue, about what IP rights entail and how you protect them. The Obama administration was, in its words, sympathetic, at least in its policy direction, to limiting the breadth of IP rights. If Biden wins, if the FTC brings this case to the Supreme Court, if it gets there, it could be the interesting case of either the Department of Justice changing its mind, saying until now, in the previous administration, we supported the defendants, but we've changed our mind. We are now sitting at the table with the FTC. And we think the Supreme Court should take this case because God knows we were wrong. What were we thinking? Or if the transition takes place when the case is at the Supreme Court, coming into the Supreme Court saying, my God, we were wrong. Our apologies. The FTC was right. What happens if the FTC wins? It gives a big boost to the prosecution of Section 2 cases in the US. It makes a big difference to the government. Why does that matter? By the end of this week or next week, the DOJ is probably going to sue Google. By the end of this calendar year, the FTC is going to bring a monopolization case against Facebook. And the state governments will bring separate cases involving both of these companies. They may join the federal agencies in their case, but they're going to bring their own. The prospects that these succeed increase if the FTC wins this case. If the FTC wins this case, these cases become much more promising. What happens if the FTC loses? This will probably give force to the proposals for legislation. It will cause Congress to say, God, you're right. The FTC tried. We think it was a responsible case, and they lost. And they lost for all these reasons that we don't believe. And suppose, as well, DOJ has a hard time with its case, or the FTC and states do as well. If these fail, that will give a big push to new legislation. The new legislation might happen without it. But part of what I think is going through the mind of these government agencies now in bringing these cases is, if we lose, so what? If we lose, that may be the step that is necessary to get us a new law that makes it easier to win in the future. I am delighted to respond to your questions and comments.
Thanks, Professor. I think we have 4 questions at the chat.
I do see questions in the chat.
Yeah.
Okay. Bruno, do you want to read them out?
Sure.
Instead of my putting my giant head right in the middle of the screen, if you like.
Sure. So, a question from Kadi, from Jad. Professor Kovacic, good morning. I would like to know your opinion about this position of the Neo-Brandeisians against the acquisition by big techs of smaller competitors. My concern about this position are that some of those companies, especially startups, were created with the clear intent of being bought by bigger companies.
I'm not fond of the categorical prohibition. I'd like to see more evidence that gives me a better way to predict likely effects. Especially, I want to see evidence of the following kinds. I want to see evidence that suggests that there will be a conscious awareness on the part of the buyer that this is a threat and we have to suppress it. That's one kind of evidence. I would like to see evidence that shows that the buyer in the past has acquired promising new companies and done either nothing with them or has promoted their development in ways that is very weak compared to what might have happened. If that evidence doesn't exist, the concern that you mentioned becomes a greater concern for me too. That if you tell them no, I guess I'm also interested in seeing which other firms might be potential buyers. That is, will other investors emerge to support new ideas? They might. I'd like to know more about that. But a total prohibition, which is what is suggested in the legislative proposals, I think would be a mistake. There's an academic named Eric Hovenkamp, who's written the best paper I've seen that would impose some controls, but in many ways, I am channeling Eric Hovenkamp's ideas about what restrictions you would impose on that theory. Substantial dominance, some evidence of anti-competitive attack intent from the business records. Third, evidence that bears upon how the company has treated its acquisition targets in the past. But not a complete prohibition.
Okay. Another question from Priscilla Brolio. Professor Kovacic, good morning. It has been a great and very clear presentation so far. Could you please comment on the Supreme Court's power and interest in examining antitrust cases? The Apple Books case seemed a good one to be reviewed by the Supreme Court, but it was turned away. Does the court have full discretion to admit or turn cases away?
It has complete discretion over this part of its docket. Until the 1970s, through the 1970s, there was a statute that obliged the Supreme Court to take any appeal brought by a government agency, brought by either the Department of Justice or Federal Trade Commission. And over these cases, the Supreme Court had no discretion at all. And those appeals could be brought from the court of first instance. So when you read older US cases, you notice that the decision taken in the first instance was by the court of first instance with no intermediate appeal. Congress repealed that act. So now the Supreme Court has complete discretion. A problem in going to them is that it is a very conservative court now when it comes to antitrust. Although the result in Apple versus Pepper was surprising. And the Justice Kavanaugh opinion has a very broad testimonial to why antitrust law is good for us. The good things it does, how it's crucial to serve the purpose of repairing the damage done to individuals by monopolists and cartels. And one asks oneself, does he really mean that? How much does he really mean that? So they have broad discretion, but the fear that has always affected the government agencies is if they take my case, they're going to kill it. I would not be that risk averse. I would make good arguments to take the cases, and I would do my best to win. In the previous decade, in the last 10 years, the FTC has had 3 cases in front of the Supreme Court. One is activists. One is a hospital merger case called Phoebe Putney. The third is a case involving the effort to get a state actor to restrict competition, so-called state action. The FTC won all 3. And I know that the recommendation to the board about whether to bring the cases and seek appeals from legal services was more likely than not you lose. They're too conservative. More likely than not you lose, which was not silly advice, but the fact that the FTC won all 3 suggests that if this were mountain climbing, there's a way to the summit. You can get to the top of the mountain. You have to be very careful. It is dangerous. And yes, you might say that the highest level is what is called on Mount Everest the death zone, where your body starts to die, but there is a way to the top.
Thank you. We have another question from Alden from CADI. Thank you for the lecture, Professor. The antitrust goals raised by the Neo-Brandeisians sound reasonable if we think for the goals of the whole state itself, but they can be conflicting in certain cases. Are there proposed methodologies to arbitrate in case of conflict?
See, these are such good questions. These are just the right questions. You have anticipated the direction of the debate. To my view, the Neo-Brandeisians have not provided an operational framework that addresses how to resolve these tensions. Their partial answer is, if you create powerful structural presumptions that limit the freedom of dominant firms, you will avoid the need in most instances to make trade-offs. That will solve most of the problems. What they don't quite address is if you give them the hypothetical problem of the kind you would like to give on an examination in the classroom, where you assume, say, going back to the example of a merger, assume that the dominant firm is going to be able, through a merger or through a unilateral practice, to dramatically increase output. Suppose it plans to do that. It does. It faithfully does that. And the increased output brings prices down to consumers, maybe gives them a new service that they could not get before. So just looking at the consumer, this is great. What about the effect on entrepreneurship? Well, if it encourages more people into the market, that would be good. But what do we say about the disappearance of a company that could have maybe grown on its own? It's an independent entrepreneur that's no longer independent. Well, let's accept the idea that we lose that. I suppose in some way it entrenches the dominance of the big player, and it makes the dominant player more effective in lobbying public officials, campaign contributions, which Brazilians and US citizens understand have a role in their political systems and not always a good one. So now I'm going to have more money to spend on political campaigns, and I'm going to be able to spend more money to send people to Brasilia and to Washington to go to those government buildings and to go, most of all, to the parliament and to lobby them. So let's assume there might be some adverse effect on democracy. How do we measure that effect? How do we trade off these adverse effects against the loss of price competition or maybe the new product? The Neo-Brandeisians do not really answer this question for us very well. I think I know what their answer is. We would willingly sacrifice the efficiencies for the admittedly hard to measure benefits of having more independent firms and a more democratic system. I'd say we give it up. We have faith that the positive impact is greater. So if Lena Khan and her colleagues were right here in this conversation, they'd say strong structural limits on dominant firm behavior get you most of the way there. But ultimately, democracy benefits, and that's the value we emphasize. So if you're asking me, are we willing to give up efficiency for the sake of these other values? Yes, we are. It's worth it.
Thank you. Another question from Antonella from Marval in Argentina. Thank you, Professor, for your invigorating presentation talking about the Neo-Brandeisian movement. I was wondering if in the US there is any ongoing case against on-demand delivery apps, or if at least there is any antitrust concern. During this year, delivery apps like Glovo, Rappi grew exponentially because of the pandemics by charging high commissions to restaurants and providing modest pay to freelancers, delivery men. In Argentina, there is yet no antitrust cases addressing the gig economy and multi-sided platforms. Is there any antitrust concern in the US regarding these platforms? In your opinion, should then be investigated?
There have been cases. There have been private cases brought by some member states have brought cases alleging that the increase in the delivery prices by the delivery apps companies constitute price gouging. So there have been a set of cases brought under member state consumer protection laws to challenge some price increases as excessive pricing. In abusive dominance law, we would call it excessive pricing, but these are consumer protection statutes that have specific prohibitions dealing with price gouging. So one set of cases has challenged them for charging prices that are inappropriately high, taking advantage of consumers in a time of crisis. As far as I know, none of those cases have been resolved. And I don't know that any of the delivery app companies have paid any damages yet, monetary settlements to resolve the cases short of litigation. So we have price gouging cases against some of the delivery apps. Second, Uber and Lyft drivers have brought cases challenging what they allege to be the failure to provide appropriate wages. Some of these cases allege that the app developers have agreed among themselves to limit artificially the wages paid. Some of the cases have been brought by state governments alleging infringements of state labor law, claiming that the app developers are failing to pay the specified minimum wage that their employees should receive. And the companies are defending by saying, these are not our employees. They're not employees. These are fee-for-service independent operators. They are not our employees. And that issue is being litigated in the courts now. There have been some courts that have said, at the state level, that have said, this relationship is employer-employee. You are employees, you have to pay a higher wage. Other courts have said, no, you're not employees. Still other courts have said, You drivers, look at your contracts. There's a mandatory arbitration clause there. You have to go through our arbitration. You can't come here first. When you're done with arbitration, maybe come see us, but arbitration first. So in some instances, the barrier to the cases has been the arbitration clause that says arbitrate any disputes first. So to this point, no federal cases involving, no cases by the national agencies under the antitrust laws. Lots of cases brought in the state courts or in the federal courts at the state level, relying largely on non-antitrust causes of action, labor law, employment law, price gouging, or state law that deals with unfair bargaining.
Thank you. Another question from Bruno Droghetti from CADI. Professor Kovacic, thank you for your amazing class. I would like to know your thoughts on the influence of the Neo-Brandeisian movement in developing countries and whether agencies in such countries would be prepared to play a broader role in antitrust and consumer and privacy protection. Thanks.
I think it's going to have an influence. I think that the literature being generated, the ideas being generated are being popularized globally. So I think there is going to be a feedback. Interestingly, many of the Neo-Brandeisians look to experience in emerging markets and in other countries to support what they're doing. That is, they look at the laws of many emerging markets and they see in those laws a broader collection of purposes. Many setting out purposes that involve concern for small and medium enterprises. Some of them, for example, in South Africa, specifying the protection of historically disadvantaged groups as a purpose of the competition law. Looking at the treaty on the functioning of the European Union and seeing a variety of provisions that deal with values and considerations that go beyond a narrow conception of consumer welfare. So the Neo-Brandeisians in many ways have absorbed the values that appear in many other laws, especially emerging markets. And at the same time, in creating a new synthèse of goals and objectives, are reinforcing, I think, the interest in many countries to revive the application of these other goal frameworks and to do it without any apology. I think in some countries, the view is that especially the United States has been going around the world, the mainstream antitrust traditionalists in Europe and in the United States, who like the consumer welfare framework, have been going to many emerging markets and saying, consumer welfare, consumer interests only. Look at the consumer. That's all you need to know. And I think now the view is the Neo-Brandeisians are going back to those countries. They're creating a literature and a body of arguments that say, don't listen to these guys. These guys are wrong. That's not what competition law is about. And the core Neo-Brandeisian argument is competition law is about the protection of good governance. And for democracies, it's about power, economic power, and how it corrupts the operation of democracy. And that if you don't attack large concentrations of economic power by themselves, you will lose your country. So their basic appeal globally is, why is competition law good? Yes, it makes the economy run better. They argue that. But they say it makes your country run better because it protects its public institutions from corruption and control by economic interests. I think in many countries that argument is going to have power. But I go back to our colleague's earlier question. Interesting, it's inspiring, but how do you apply it in practice? What do you do about trade-offs? And that's going to be the hard challenge, I think. But the basic argument that this is about power, controlling power, and protecting your nation globally, I think that's going to be a powerful message. And at a minimum, what they have done is they have put that issue front and center in the debate. They've done that. And they've done that in a powerful way, which is why, in so many ways, I go back to these guys. Sorry. There they are. Barry has been writing this for 20 years. He was writing it when nobody would pay attention. Lena has been doing it for less than 5 years, roughly 5 years. A very young person who made a very big difference. And in some ways, they are using and building ideas that go through the history of anti-monopoly policy. You know, a vision of competition law that is not just about a lower price product, a higher quality product or service, but about the power of competition and anti-monopoly as tools to protect the integrity of the political process. They are going back to that theme, both of them. They said, this is the high ground. This is the purpose. And if you ask them, is the main purpose of competition law to provide lower cost goods and services or higher quality? They'd say that's really important, but that's not the main reason. Say the main reason is to protect the integrity of the political process, especially democracies. Which is why they love this quote. It's why Lena put that quote at the front of the report. We may have a democracy or we may have wealth concentrated in the hands of a few, but we cannot have both. That they believe more than anything else. That's a powerful message, isn't it? Even before we start talking about how you apply it in practice in hard cases. But that's their message. I would say in many countries, that's a message that resonates both in the mind and in the heart, which is why one takes it seriously. Yeah.
Thank you, Professor. I have two quick questions for you.
Please.
Yeah. First, first one is from my limited knowledge about the U.S. system, I haven't seen such activity on the state level as we've been seeing now. I don't know if this has been seen before, but how able the state enforcement is to influence federal government activity, and how much have they been influenced by the Neo-Brandeisian approach? I think that's the first question. And the second one is a quick one, relates to the quick look decision on American Express that limited that to vertical restraint cases. Do you agree with their opinion? Should the quick look only be applied for vertical, for horizontal cases? Or what's your opinion about it?
Yeah, thanks again for these excellent questions. On the first one, the states very much embrace major themes from the Neo-Brandeisians. And many of them would define themselves as very sympathetic to that point of view. But again, going back to our colleagues' very good question about how you do this, and you look at this set of goals, a number of state officials, to go back to the earlier list, where are the states now? The states are very much in line 2, do much more with what you have, and they would very much agree with line 3. They are nervous about abandoning the consumer focus, many of them. Now, you can define the consumer focus broadly. You can define the consumer focus broadly in some ways to include workers. that monopsony power exercised in certain ways is ultimately bad for consumers because it hurts workers. But I would say the states are very happy about the root and branch critique because it gives power to their own efforts to do more. This is the most ambitious recent effort that they've ever developed, to develop a big monopolization case against big tech. Broadest in their history. They've done other major things. This is the biggest. And they would say the Neo-Brandeisians have created an environment in which the big case brought by us is more feasible. And it's encouraged us to work creatively and work collaboratively to do this. But if you said, so you want this framework of goals, is that what you're saying? You want these goals? A number of the states would say, I can't quite go that far. I can't do that. I'm afraid that this is too hazy and open-ended. I can't go that far. And they're having a big influence on the federal government because they have competence to bring their own case regardless of what the federal government does. The federal government acting or not acting does not oust them. They get to do what they want. They have independent competence to do that. And the fact that the states are saying, we will go ahead no matter what, that pushes the federal agencies too. On the quick look, I think the American Express case, I think it's a matter of analysis and policy. Sorry. There we go. That footnote, I think, is a mistake. The footnote that says you can't apply the quick look and vertical restraints cases, I think, is a misunderstanding of the purpose of the quick look, the logic for it, and what earlier cases have said. There is nothing in the jurisprudence that approved the quick look that said this is only for horizontal cases. And the logic of the quick look is that where you have behavior that is competitively dangerous, the burden should be stronger on the defendant to justify it. And in this case, the Department of Justice had direct evidence of adverse effects too. So I think that's a mistake. It bothers me that they put it in a footnote. Put it in the text. Explain why you're doing it in the text. Don't put it in a footnote. I find this most unfortunate. If you were an instructor grading an examination and you saw this kind of observation in an essay, you'd say, that's interesting. Explain to me why, but can you show me? Or if it were a paper by a student and you saw this and you said, where do you get this? Tell me why. Yeah, are there any cases, Supreme Court cases have said that? The answer would be no. So tell me the policy reason, but the Supreme Court does not provide, doesn't explain this very well. Unsatisfying.
Thank you.
But they get to grade their own papers. So and they don't care what academics have to say. They say, thank you, Professor, very much indeed for that. Go away.
Do we have time for one last question?
Absolutely, yes.
Okay. So from Beatriz, Professor, first of all, thank you for making the time to be here with us. As a law student, I have a question regarding the FTC versus Qualcomm case. I was really interested by the FTC's petition for hearing Unbank basically arguing that consumer protection is beyond the scope of antitrust law. how would a supporter of the Neo-Brandeisian movement balance this lack of control of a large company with concentration of power, with the Ninth Circuit decision determining that unless you have a direct harm to competitor impacts on consumer do not matter? I understand that the Neo-Brandeisian have a view that a citizen welfare is the goal rather than consumer welfare. But would he go as far as to say that consumer protection goes beyond the scope of antitrust law?
I think they would say, in this instance that the court did several things wrong. One is the practice at issue here would be the type of practice they would treat as always illegal by a dominant firm. That is, they would probably accept the FTC's idea in this case that this was basically, they would say two things about the FTC theory. They would say one is that this is exclusive dealing. This is telling a purchaser of chips, a smartphone manufacturer, you deal with me. If you deal with someone else, you're going to pay for it. I'm going to make it really expensive for you to deal with someone else. And a reason you're going to continue dealing with me is that I'm the only one who makes some of the chips you need. So some chips, you have to buy them from me. You have no option. And because you have to deal with me, I'm gonna charge you a fortune for those chips if you deal with someone else. So one thing the Neo-Brandeisians would say is dominant firm exclusive dealing per se illegal. The second is dominant firm has a duty to deal. They would abandon Trinco completely and say that dominant firm, what they would sometimes call a gatekeeper, obligation to deal. So they would say, we don't even have to get to the question of injury. We presume injury to competition from these practices if it's a dominant firm. They would say, that's all we have to say. We're done right there. If you press them more and say, well, shouldn't we look at who is injured? They'd say, we think it's relevant that the chip manufacturer, the rival chip manufacturer is injured. That counts. That the OEM is injured because they pay a higher price. That counts. And yes. I mean, this is a case where we agree there's consumer injury. But we would not require proof of injury to any of those groups. It would be inferred under our framework because it was a dominant firm that did one of these two things. Dominant firm that imposes exclusive dealing, a dominant firm that refuses to deal. Both of them, per se illegal. So that means you skip the process of proving competitive injury because there is an inference of injury when a dominant firm does either of these.
Okay, so I think we overpassed 20 minutes from the time we agreed. We thank you a lot, Professor, for your very clear presentation, and it was very nice for us to actually hear from an authority like yourself what is going on in the U.S. And it's I emphasize it's a pleasure and honor for us. And we'll be counting on you for the next 2 weeks as well to learn more what is going on in the U.S.
I look forward to it with great enthusiasm, and I'm so grateful to you for the chance to do this. And I've looked forward to this for months, and it's a delight. It's a delight to do this. And Bruno, I have a couple of other things that talk about these implementation issues. If you don't mind making available to people a couple of other papers that talk about some of these topics, I'm most happy to give them to you.
Oh, that would be great, and then we can circulate to the whole group.
With pleasure. But thank you for this, and for allowing me to do this. To put this in the context of the current debate, which I can't predict exactly how the debate will unfold, but it's a very serious debate, and thank you for allowing me to have some time to place the context of agreements and cartels in the bigger framework, just to alert you that some of the foundations of the modern U.S. jurisprudence would be pulled away if there were the big change that's been suggested here. So thanks for the chance to do this as well.
Okay.
And I look forward to cartels next week and then mergers the week after.
Yes.
Where you will hear a little bit of this again, because it is the same debate, certainly for mergers. And even some debates about cartels, about whether smaller enterprises should be able to collude. Bit on that.
That's great.
Yeah.
Lauro, do you want to say some words?
No, just thank you, Professor. It's been a fantastic lesson we had here. Of course, we are always thinking about how to, not how to implement, but how to focus in our legal systems and how to use those new principles on our Brazilian legal system, which is quite different from the United States. And the principles we have here, economic principles, and what level of independence we have from the antitrust authorities here in relation to the courts, because we are here in let's say, we may have a fight here within the antitrust system, but we do not have actually the same influence that the courts have in the United States. So how to discuss this new antitrust frontiers here in Brazil, it's a little more complicated.
Well, Lauro, can I mention one thing that does concern me in this?
Okay.
Touch on it. I think of my time at the U.S. Federal Trade Commission and my time now at the Competition and Markets Authority, and from the point of view of an enforcer, suppose the law says do all of these things here.
Mm-hmm.
It's a very broad mandate with, as our colleagues have said, tension. And nothing in the law will tell you how to resolve the tension. But it's also puts you in a position of making very broad policy judgments that we usually tell legislators to make. Open markets, a fair economy. So my mandate, I'm the enforcement official. I'm told, go create a fair economy. Or I'm told, preserve democratic ideals. My initial reaction is that's what you want a legislature to define for you. And I start to become concerned that the broader my mandate, the more objectives, the more open-ended the objectives are, the more that elected officials will feel comfortable telling me how to do this.
Mm-hmm.
Because they say, that's what we do. And because your mandate is so broad, we're going to tell you how to do it. And I become concerned that it's not long before they're telling me all the time how to do this. And that this is an invitation for political pressure to come into my life. Because if I think of why do competition agencies so often like to say, we do law enforcement, and our aim is to protect consumers, consumer interests. I think part of the reason is that we like enforcement because that's going into the courts. It's a judicial process. So don't tamper with the judicial process. Consumers, it's more narrowly focused. Yes, in a sense, it is more technical.
Mm-hmm.
But that's partly a way of telling elected officials, get off my back. I'm a professional. I am doing a somewhat technical job, but get off my back. Yes, I am aware of the larger social needs, but if you tell me this is your mandate, I can envision spending much more time with legislators, calling me up, bringing me before committees, and otherwise applying pressure to me to say, I'll tell you how to do this. I'll tell you what to do. Imagine it's a merger, and I'll do this in 2 weeks. It's a merger. The party comes in. Should I use the merger as an occasion to say, I want to promise that you will not dismiss any workers now employed by the two companies? I want a binding promise. I want to promise that you're going to create greater upward mobility for your workers. What if a company comes in and says, there might be a little bit more market power here, but here's what we will do for workers. We're going to add tremendous benefits. Here's the investment we are going to make in the local community. Here is our promise to make investments in independent businesses. Here are promises we're going to make about the democratic process. What happens when they bring into the analysis of the competition issue these other goals? And by the way, will the goals stop here? What about sustainability? Why not? If I am a competition official, I say, wow, I don't know how to do this. I'm not sure. But I do know that the broader this list is, the more complex, the more open-ended. I'm going to have elected officials leaning over my shoulder every day of the week telling me what to do. And they're going to say, do it because of all this. But to think of merger control is a necessary condition of merger control to say no redundancies, none. You will dismiss no one. Because maybe you'll cut your costs, but you will injure workers. Does that become part of the negotiation in every transaction? I think that's where this could go.
That's my concern, at least. What we have seen in other, not the antitrust agency here in Brazil, but in other agencies. For instance, environmental agencies, when you deal with them and you have to compromise with something to have your license or authorization, you have to discuss everything, including environmental issues. But social issues and computer and donations issues. So there are many, let's say, many actors in the Brazilian system which deals with the same thing. So consumers, for instance, you have the federal board, the state board, and the municipality board. So once you have this open concept, you give them the chance to, let's say, to try to impose you some conditions that are not directly related to their competences. So
well, and is that thing about the process is the only effective way to give meaning to these goals to have a special deliberative process where all of these voices can come into the debate.
Yeah, that's my concern too. At least as I'm an old guy, I'm more conservative, of course.
Well,
but
I was, I will not tell you in what part of Jurassic Park I was born and grew up, but I do think of my experience inside of an agency where, by the way, elected officials applied pressure on these issues a lot, especially on workers.
I see.
In mergers, I got phone calls all the time from elected officials on mergers. And what do they care about most? They had an idea what would happen to employment in their constituency. If the employment was going to go up, they liked it. If it was going to go down, they hated it. So their eyes were first and foremost on what's it going to do to the jobs in my constituency. And that was the reason they gave, to oppose it or to favor it. So that pressure is there. This, I guess you could ask, do agencies already consider that? But they do it in a very hidden way. Does this just make it more explicit, transparent? But I think it has a transformative effect, not just in the way that its advocates anticipate. I don't see why. You know, for a cartel, do I avoid criminal prosecution for a cartel by saying I did it to protect my workers? That is, I know that some of the companies in the cartel were struggling, but by spreading the work around, we were able to ensure that everybody kept their jobs, that nobody was fired, and this protected my community. You know, I had no intent to injure anybody. My only aim was to protect my workers and to make sure nobody got fired. That's why we had the public procurement bid rotation mechanism that allocated contracts. At a minimum, in this rule of reason, when we get down here, does that kind of argument help me avoid per se illegality? If it's a criminal prosecution, which matters in a lot of this hemisphere, doesn't it? A lot of our jurisdictions have the power, the competence to prosecute horizontal agreements of some kinds as crimes. Is this a basis for getting me out of a criminal prosecution? Can I go to COFESA, one of the criminal prosecutors, and say, bring a civil case, but this is not criminal. I had a good social purpose. Does the same argument work with the Department of Justice? And where does that kind of balancing fit into this framework? I did it for my workers. Now, you might doubt whether that was my motive, and I guess I'd have to prove that. But does it even become part of the conversation? You know. So in a lot of ways, there are complications. You know, if this were medicine, let me see. Yeah, I've got a bottle here. Got some vitamins. Here's medicine. On medicine bottles, there is a panel called side effects. You can't read it here, but these are called side effects. And it says, if you take these tablets, here's what could happen depending on who you are. I think for the big package, the modern transformation reform, they haven't really written out the side effects yet. In some ways, we haven't thought through them. But before you use the product, I think you want to know. You might take them anyway, but you might be careful about the dosage.
Sure. Thank you.
Yeah.
Okay.
Okay, so thanks, Professor. See you next week.
See you Tuesday. See you Tuesday. Thank you. Thank you for your generous opportunity to do this. Thank you both. Thank you all.
For an amazing class.
Thank you.